When you hear the phrase justice is blind, what do you actually picture? Like, really picture in your mind's eye.
Oh, I mean, probably the classic statue, right?
Yeah, exactly.
Yeah.
Lady Justice. You know, the one holding the perfectly balanced scales with that blindfold tied tightly over her eyes?
Right, right.
It's this really comforting image of a neutral judge, a fair trial, a system that only looks at the raw facts of what happened. But what if that blindfold is just, what if it's a complete myth?
Well, that's the big question, isn't
Yeah.
it?
Because what if the reality is that the American justice system actually sees absolutely everything, like your wealth, your zip code, the political climate in your town, the quality of your lawyer, and it sees all of that before it ever even glances at the facts of your case. So, welcome to this deep dive into the source material.
It's a really profound question to start with. Because if that blindfold is a myth, I mean, implications for how we understand our society are just staggering. We aren't just talking about a few bad apples in a courtroom, or an occasional mistake in a trial. We are talking about the very foundations of how the state deprives a person of their liberty.
Which is huge.
It is. If the system is structurally designed to see wealth and status before it sees facts, then we're dealing with a crisis of constitutional proportions. The stakes literally could not be higher for you, the listener, or anyone else.
And to really dig into this, we are looking at an incredibly provocative, highly detailed essay by an independent researcher, Zachary David Enfield.
Right?
It's called Processed Before Protected: Equal Protection and the Unequal Machinery of American Justice. And our mission for this deep dive is to essentially deconstruct this machinery of the American justice system.
Which he maps out in incredible detail.
He really does. Enfield makes this bold argument that the constitutional promise of equal protection has just been entirely replaced by an unequal assembly line.
Yeah, that's a great way to put it.
So we're going to follow the whole life cycle of the law today, all the way from the political campaigns that write the statutes down through the system and into the literal jail cell where a plea deal is signed. I have to admit, this framework completely upended how I've always thought about the law. We really need to decode how this actually works.
Enfield's analysis is so compelling precisely because it's systemic. He is looking at how structural inequality is legally permitted under current constitutional doctrine.
Permitted.
Yeah, legally permitted. He points out this massive gap between what the text of the Constitution promises and what the courts have decided is actually required to satisfy that text.
Okay, let's unpack this. What's the fundamental premise here?
The fundamental premise of Enfield's essay is what he calls the whole machine illusion.
The whole machine illusion.
Right. The idea is that equal protection under the law cannot just mean assigning a defendant a case number and giving them a lawyer's name. Protection, in the constitutional sense, means that the entire machinery standing between the accused and the power of the state must protect equally.
Okay, that makes sense.
But if every single part of that machinery is unequal, I mean, the funding, the judge, the bail system, the prosecutors,
Yeah.
then the final result cannot possibly be equal justice. It's just unequal protection being processed through constitutional language.
It makes me think of an assembly line.
Sure.
Like, imagine a massive factory that builds cars. You have all these different stations, right?
Right.
If every single station on that assembly line does a terrible job, like the engine block is cracked at station 1, the brakes aren't aligned at station 2, the steering column is installed loosely at station 3.
That's a death trap of a car.
Exactly. But if every worker technically followed the literal bare minimum steps in the employee manual, the factory manager can't just stand at the end of the line, point to a clipboard and say, well, we checked all the boxes, so we built a safe working car.
Right, because the car is fundamentally broken.
Yeah. The clipboard is just the docket. It records that the procedure happened, but it completely conceals the physical reality that the product rolling off the line is broken and dangerous.
That analogy captures the exact mechanical failure Enfield is describing. The docket records the procedural skeleton, but it conceals the massive pressure that actually produced the outcome.
So how is this assembly line legally allowed to operate this way?
To understand that, we have to look at the gap between the 14th Amendment and judicial doctrine. The 14th Amendment plainly says that no state shall deny any person the equal protection of the laws.
Which sounds pretty ironclad.
It does. But the Supreme Court has interpreted that text in ways that narrow its application significantly. Enfield points to two critical foundational cases here that set the stage. One is San Antonio Independent School District v. Rodriguez, and the other is Washington v. Davis.
Okay, let's break those down because I really want to understand how the highest court in the country interpreted equal protection to allow for this broken assembly line. What happened in the San Antonio case?
So, San Antonio ISD v. Rodriguez was a massive case from 1973. It was essentially about how public schools are funded. In Texas, like in many places, school funding was heavily tied to local property taxes.
Right, which means richer neighborhoods get richer schools.
Exactly. This meant that Edgewood, which was a predominantly poor neighborhood with low property values, could tax its residents at a much higher rate than the wealthy Alamo Heights district nearby, but still end up with a fraction of the funding per student.
Because the houses are just worth less.
Right. So the parents in Edgewood sued. They argued this system violated the Equal Protection Clause because it fundamentally discriminated against poor students. They argued that wealth should be considered a suspect classification.
A suspect classification. What does that mean in legal terms?
It means any law that discriminates based on wealth should face the strictest scrutiny from the courts, just like laws that discriminate based on race or religion.
So they were basically asking the Supreme Court to acknowledge that penalizing someone for being poor is fundamentally unconstitutional. What did the court say?
The Supreme Court ruled against the parents in a 5-4 decision. They held that wealth is not a suspect classification.
Wow. Really?
Yeah. The court essentially said that as long as the state is providing some absolute minimum baseline of education, differences in quality based on local wealth do not violate the Constitution.
That is a staggering precedent.
It really was a watershed moment.
Yeah.
By declaring that poverty is not a protected class, the court gave the green light for massive systemic disparities across all government services. And that absolutely includes the justice system.
Okay, so as long as the government isn't explicitly targeting you for your race or religion, it's perfectly fine if the system completely crushes you just because you happen to live in a zip code with low property value.
That's the practical effect, yeah.
And what about that second case you mentioned, Washington v. Davis?
Right, so Washington v. Davis came down in 1976, and it compounded this doctrine. This case involved a written personnel test used by the District of Columbia Police Department. Statistical evidence showed that black applicants failed the test at a disproportionately higher rate than white applicants.
Okay, so a clear disparate impact.
Exactly. The plaintiffs argued this violated equal protection because of that disparate impact. But the Supreme Court ruled that a law or official act is not unconstitutional solely because it has a racially disproportionate impact.
Wait, then how do you prove it's unconstitutional?
To prove a constitutional violation, they said you have to prove discriminatory intent.
Hold on. You have to prove the lawmakers or the system designers were actively, purposefully trying to discriminate in their own minds.
Yes.
How do you even prove that? Do you have to find like a leaked email or a diary entry where a lawmaker explicitly says, I am writing this law specifically to harm this group?
That is precisely the burden, and it is nearly impossible to meet. Unless an official is foolish enough to write down their discriminatory motive, systemic bias is shielded from constitutional challenge.
That's wild.
So together, Rodriguez and Washington v. Davis created a doctrinal reality where a system can produce radically unequal, devastating outcomes based on wealth and geography. And as long as nobody wrote down an evil intent, it is considered entirely constitutional.
Which brings us to what Enfield calls the illusion of the procedural floor.
Exactly.
So this is where we get into the actual protections the Constitution supposedly guarantees. And the most famous one is obviously the right to an attorney.
Right.
Everyone knows the Miranda warning line from television. If you cannot afford an attorney, one will be provided for you. That comes from Gideon v. Wainwright.
Yes.
Right.
Clarence Earl Gideon was a poor drifter who was accused of breaking into a pool room in Florida in 1961. He asked the judge for a lawyer, but Florida law at the time only provided lawyers for capital cases.
So he was on his own?
Completely on his own. Gideon defended himself, did a poor job, and was sent to prison. He famously hand-wrote a petition to the Supreme Court from his prison cell.
Oh, wow. Hand wrote it.
Yeah. And in 1963, the court ruled unanimously that the Sixth Amendment's guarantee of counsel applies to the states, and that indigent defendants must be provided a lawyer. It was heralded as a massive triumph for equal protection.
I mean, it sounds like a triumph. The state is finally forced to level the playing field, right?
Well, it was a triumph in theory. But Enfield argues that the Supreme Court later completely undermined that promise in a 1984 case called Strickland v. Washington.
How so?
While Gideon promised a lawyer, Strickland set the constitutional minimum for what counts as effective counsel, and the standard they established is incredibly, shockingly low.
How low are we talking?
The court essentially said that to prove your lawyer was so bad that it violated your rights, you have to prove two things. First, that the lawyer's performance was objectively unreasonable. And second, that there's a reasonable probability the outcome would have been different if the lawyer had done a better job.
Okay, that sounds somewhat logical on its face.
It does, until you realize the court also added a highly differential standard that warns judges against second-guessing a lawyer's tactics in hindsight.
Okay, so what does objectively unreasonable actually mean in practice? Like, how bad does a lawyer have to be to fail that test?
To give you a sense of how low the Strickland floor is, there are well-documented, highly publicized cases where defense attorneys literally fell asleep during parts of a death penalty trial.
You're kidding. Fell asleep.
Literally unconscious. The defendants appealed, pointing out that their lawyer was asleep while the state was presenting evidence. And appellate courts have sometimes ruled that, under the Strickland standard, this did not constitute ineffective assistance of counsel.
Wait, why?
Because the defendant couldn't definitively prove that the lawyer sleeping changed the ultimate outcome of the trial.
That's insane. A sleeping lawyer is considered effective counsel.
Under that standard, yes.
It's like being promised a life jacket, but when the boat sinks, they hand you a life jacket made of tissue paper. Like, technically, the state gave you a flotation device, so the procedural box on the clipboard is checked. The rules were followed. But you're still going to drown.
That is the perfect way to describe the illusion of the procedural floor. The form is there, but the substance is missing. And this leads to a massive doctrinal problem when someone tries to actually sue the government for violating their civil rights.
Okay, how does that work?
Enfield analyzes Section 1983, which is a federal law that traces back to the Civil Rights Act of 1871. It's the primary vehicle citizens use to sue state actors for constitutional violations. But under Section 1983, the doctrine of standing requires you to identify a single discrete government actor who caused a discrete injury.
Okay, so you have to point fingers.
Right. You have to point to one specific bad apple and prove they intentionally violated your rights.
But Enfield's whole thesis is that the system is a whole machine. It's not one bad apple, it's the entire orchard.
Precisely. The judge, the prosecutor, the jailer, the public defender, the clerk, all of them can legitimately point to their own narrow procedural rulebook and say, look, I am just acting lawfully within my tiny little lane. I followed my specific rules.
Right. The public defender filed the motion.
The judge heard the motion.
The prosecutor made an offer.
The jailer turned the key. They can all claim they're doing their jobs perfectly legally.
Mm-hmm.
But cumulatively, the crushing weight of their combined actions destroys the indigent defendant.
Because it's an assembly line.
Exactly. Section 1983 completely struggles to address this because it wants a single villain. It wants the factory worker who maliciously broke the steering column. It doesn't know how to sue the assembly line itself.
It's like death by 1,000 paper cuts. And the court is asking you to prove which specific paper cut was the fatal one, while completely ignoring the fact that you were just pushed into a giant paper shredder.
Yes.
So is there any legal precedent for the courts actually looking at the whole machine, or are we just stuck with this narrow view forever?
Well, Enfield does find a glimmer of hope in the jurisprudence. He points to a 1983 Supreme Court case called Bearden v. Georgia.
What happened in Bearden?
Danny Bearden was put on probation and ordered to pay a fine and restitution. He lost his job, couldn't find a new one, and couldn't pay the fine. So the state revoked his probation and sent him to prison.
Just for being too poor to pay.
Exactly. But the Supreme Court actually ruled in Bearden's favor.
Yeah.
They held that a person cannot be imprisoned or have their probation revoked solely because they are unable to pay a fine without the court considering the reasons why they can't pay.
Okay, so if you're trying, they can't just lock you up.
Right. If they're making a bona fide effort, you can't just lock them up for being poor.
So in that specific scenario, the court recognized that the state's combined apparatus, the fines, the probation, the incarceration, it was all operating as a wealth penalty.
Yes, exactly. In Bearden, the court actually evaluated the cumulative effect of the state's actions against the guarantee of equal protection.
Mm-hmm.
Enfield is arguing that we desperately need to take the logic of Bearden and generalize it to the entire criminal justice machine.
Mm.
We have to stop looking at the individual gears and start evaluating the machine as a whole.
Okay. If that completed docket is just a procedural skeleton, a tissue
Yeah.
paper life jacket, as we said, what is the flesh and blood reality that is putting all this pressure on the accused?
That's the real question.
Right. If we step off the theoretical level and walk into the physical courthouse, what is actually happening? Let's look at the very first gear of this machine, the pretrial environment.
Yes, this is crucial.
Because when we watch legal dramas on TV, every single episode ends in a dramatic trial. There is a surprise witness, a brilliant cross-examination, and a jury reading a verdict. But trials are actually a statistical anomaly in real life, aren't they?
They are nearly extinct. Trials are the constitutional default in theory, but they are the statistical exception in reality. Data from the Department of Justice's Bureau of Justice Statistics shows that approximately 95% of state and federal felony convictions come from guilty pleas. 95%.
95%. That means the vast, vast majority of the time, the state never actually has to prove its case beyond a reasonable doubt to a jury of your peers. The system is fundamentally just a plea bargaining apparatus.
This is where Enfield's analysis of pretrial detention becomes so critical. If 95% of cases are resolved by pleas, we have to look very closely at the physical environment where those pleas are being negotiated.
Right. Where is the person when they are making this choice?
Exactly. Research from the National Bureau of Economic Research, specifically a working paper by economists Dobby, Golden, and Yang, along with extensive years-long data from the Vera Institute of Justice, proves that simply being held in jail pre-trial drastically increases the likelihood that a person will plead guilty.
Walk me through how that actually happens on a human level. Why does the physical cage change the legal case?
Because jail is not a neutral waiting room. It is an actively destructive environment. Imagine a person gets arrested on a Tuesday. They can't afford the cash bail, so they are sent to the county jail to await trial, which might be 6 months away.
Okay.
By Thursday, they don't show up for their shift at work, so they get fired. By the next week, they can't pay their rent, so their landlord starts eviction proceedings.
Oh, wow. It just spirals immediately.
Rapidly. Their children might be placed with relatives or in foster care. Their car might be impounded and sold for fees. They are surrounded by noise, violence, and profound isolation. Their mental stability begins to deteriorate.
So their entire life on the outside is just evaporating while they sit in a cell?
Exactly. So when a prosecutor comes to them a month later and says, look, we can take this to trial in another 5 months, and if you lose, you're looking at 3 years. Or you can sign this piece of paper pleading guilty right now, and I'll give you time served in probation, and you can walk out of those doors this afternoon.
I mean, who wouldn't take that deal?
Exactly.
Yeah.
That is not a free constitutional choice. It is a hostage negotiation. The defendant isn't weighing the legal merits of the state's evidence. They are trying to stop the bleeding. It is survival bargaining.
And this ties directly into the issue of cash bail, because who is sitting in that cage experiencing that pressure? It's the people who don't have the money to buy their freedom.
Enfield argues that cash bail is effectively wealth-based detention. He extends the logic of older cases like Williams v. Illinois and Tate v. Short, which dealt with jailing indigent people for unpaid fines. Cash bond systems mean that freedom before trial depends entirely on your bank account. If two people are accused of the exact same crime, let's say a burglary, and the judge sets bail at $10,000, one person has savings, they pay the money, and they go home.
And their life doesn't collapse.
Right. They sleep in their own bed, they keep their job, they meet with their lawyers in a comfortable office, they hire private investigators, and they build a defense from a position of strength.
And the other person?
The other person doesn't have the money.
Yeah.
They sit in the cell. They lose their livelihood. They only see their overworked public defender for 5 minutes through a glass partition. The wealthy person is presumed innocent and allowed to live their life. The poor person is subjected to profound punishment before a conviction is ever handed down. Poverty itself becomes the engine of the conviction.
Let me pause here, because I know there is a very common defense of the system. If I am looking at this from the perspective of the courts or the legislature, I might argue that plea bargaining is just a necessary negotiation.
Sure, efficiency.
Yeah, efficiency. Because the system would literally collapse if every single case went to trial. We don't have enough judges, courtrooms, or citizens to sit on juries. So isn't a plea deal just a mutually beneficial transaction? It's like buying in bulk. If a defendant saves the state the immense time, money, and risk of a trial, shouldn't they receive a lighter sentence as a reward?
It is the standard justification, but Enfield completely dismantles that framing. He argues that calling it a discount is a linguistic trick that hides the reality of the baseline.
How so?
It is not a discount for pleading guilty. It is a massive crushing penalty applied to your constitutional right to have a trial. You do not have a right to a trial if asserting that right ruins your life. This is what legal scholars call the trial penalty.
And Enfield points to a specific Supreme Court case that essentially gave this practice its constitutional blessing. Bordenkircher v. Hayes. I was reading the background on this, and the facts are staggering. This wasn't a murder case or a massive conspiracy.
No, the facts of Bordenkircher v. Hayes, decided in 1978, are brutal precisely because they are so mundane. It serves as the doctrinal foundation for the trial penalty. A man named Paul Hayes was charged with forging a check for $88.30 in Kentucky.
$88, okay.
Under state law at the time, that offense was punishable by 2 to 10 years in prison. The prosecutor offered Hayes a plea deal, plead guilty, and I will recommend a 5-year sentence.
Okay, 5 years for an $88 check still seems steep, but go on.
Right, but Hayes refused. He asserted his innocence and demanded his constitutional right to a trial.
Which is exactly how the adversarial system is supposed to work. The state makes an accusation, and the citizen demands they prove it.
But the prosecutor had leverage. He told Hayes that if he did not take the 5-year plea, the prosecutor would return to the grand jury and re-indict him under the Kentucky Habitual Criminal Act.
Oh, boy.
Hayes had 2 prior felony convictions. If indicted under that enhancement, a conviction would carry a mandatory sentence of life imprisonment.
Wait, life in prison?
Life in prison. Hayes still refused the plea. He went to trial. The prosecutor followed through on the threat, applied the habitual offender enhancement. Hayes was found guilty of forging the $88 check, and the judge had no choice but to hand down a mandatory life sentence.
A life sentence for an $88 check, purely because he asked for a trial. And the Supreme Court upheld this. How did they possibly justify it?
Justice Stewart wrote the majority opinion for the Supreme Court. He argued that plea bargaining flows from a mutuality of advantage between the state and the defendant.
Mutuality of advantage.
Yes. The court essentially reasoned that as long as the defendant is free to accept or reject the offer, there is no unconstitutional punishment going on. The state has a legitimate interest in persuading the defendant to forego the trial, and threatening them with a much harsher sentence is simply an acceptable, necessary bargaining tool in our system.
Mutuality of advantage. The prosecutor holds a mandatory life sentence over your head, and you get to choose between 5 years or dying in prison. Calling that mutual seems like a profound distortion of the English language.
Enfield aligns heavily with the fierce dissents in that case by Justices Blackmun and Powell. They saw this exactly for what it was: the state explicitly punishing a citizen for exercising their constitutional right to a trial.
It's hard to see it any other way.
Justice Powell pointed out that the prosecutor himself obviously believed that 5 years was the appropriate sentence for the crime of forging the check.
Yeah.
The massive leap from 5 years to life imprisonment wasn't because the crime was suddenly more serious or because Hayes became more dangerous.
Right.
The life sentence was simply the price tag the state put on the courtroom door. It was punishment for asserting the right.
So the system is actively structurally designed to punish you for making them do their jobs. And this isn't just an isolated anecdote from the 1970s, is it? This is the backbone of how pleas work right now.
Absolutely. Enfield cites a comprehensive 2018 report from the National Association of Criminal Defense Lawyers. They analyzed the federal system and found that defendants who go to trial receive sentences that are, on average, 3 to 7 times longer than those who take a plea for the exact same conduct.
3 to 7 times longer.
Yes. The trial penalty is incredibly real, and it serves as a massive deterrent, scaring people away from ever seeking the truth in a courtroom.
So if the prosecutor has this overwhelming leverage to threaten you with decades in prison, and the jail is acting as a literal coercion chamber breaking down your life, who is the counterweight? Who is standing next to the defendant, protecting them from the power of the state?
It's supposed to be the defense attorney and the judge?
Supposed to be. But Enfield argues they are not on equal footing at all. Let's examine the people operating the machine. What does the reality of indigent defense actually look like on the ground?
Well, we talked about how Gideon promises a lawyer and how Strickland sets a tissue paper floor for their performance. But to understand the physical reality, Enfield relies on the American Bar Association's National Public Defense Workload Study, released in 2023. The realities it reveals are nothing short of catastrophic.
I saw these numbers in the notes, and I honestly had to read them twice. It seems physically impossible.
The ABA study sought to establish how many cases a lawyer can realistically handle while still providing adequate constitutional representation. They brought in experts, analyzed the time needed to review evidence, interview witnesses, file motions, and negotiate.
Okay, doing it right.
Right. They concluded that a defense attorney should handle a maximum of about 59 felony cases a year.
59.
In reality, across the country, many public defenders are handling upwards of 500 felony cases a year.
Let's just do the math on that out loud. If a lawyer works 40 hours a week, 50 weeks a year, taking 2 weeks of vacation, that is 2,000 working hours in a year.
Right.
If they have 500 felony cases, that means they have exactly 4 hours to dedicate to each human being's life. 4 hours to read the police report, watch the body cam footage, visit the client in jail, interview witnesses, research the law, write motions, negotiate with the prosecutor, and appear in court.
It's absurd.
It is mathematically impossible to investigate anything. You were just a signature on a piece of paper.
And that is Enfield's central point about the illusion of counsel. Private defense is a market. Public defense is a budget.
Explain that distinction.
A wealthy defendant enters the system and treats it like a marketplace. They can purchase a whole team of lawyers. They hire private investigators to track down exculpatory witnesses. They hire forensic experts to challenge the state's DNA or ballistics evidence. They hire mitigation specialists to present their life story to the judge.
They can essentially buy time.
They buy time, resources, and friction against the state. A poor defendant receives whatever the county budget allows, which is an exhausted, traumatized lawyer carrying an impossible volume of cases who might only have 10 minutes to speak with them in the hallway before a hearing.
Yeah.
The Constitution says both defendants have counsel, but equal protection has to ask. Protected equally how?
This makes me think back to that car factory analogy, but let's look at it differently. The Constitution promises you a shield to defend yourself against the spears of the state.
I like that.
If you are rich, you can go out and buy a massive, thick titanium phalanx. You've got experts and investigators holding it up with you, reinforcing it.
Right.
If you are poor, the state hands you a soggy paper plate. And under current judicial doctrine, the courts look at both of you, see that you are both holding something, and say, well, you both received a shield. The procedural box is checked. Equal protection is satisfied.
Exactly. And to make your paper plate analogy even worse, the person holding that paper plate for you is simultaneously juggling 499 other paper plates for other people.
Oh, man.
And the systemic failure extends beyond the lawyers to the judges themselves. We are taught from a very young age to revere the judge as a completely neutral arbiter. They wear the black robe, they sit elevated above the courtroom, they're supposed to be above the fray.
They're the umpires.
Right. But Enfield points out that judges are human beings who operate inside a structurally biased ecosystem.
Okay, looking strictly through Enfield's structural lens here, without getting into the politics of campaign finance,
Yeah.
how does this system compromise the judge's neutrality?
Enfield relies on extensive research from the Brennan Center for Justice, specifically looking at state Supreme Courts and trial courts in reports titled Skewed Justice and Bankrolling the Bench. Many judges in the United States are elected.
Right, they have to run campaigns.
Yes. The Brennan Center conducted massive statistical analyses of court decisions in criminal cases and cross-referenced them with campaign spending data. What they found is a direct statistical correlation between the volume of television advertising in judicial elections and the rate at which judges hand down harsher sentences against criminal defendants.
Wait, really? So if a judge is up for re-election and the local airwaves are suddenly flooded with campaign ads, maybe, from an opponent accusing them of being soft on crime, the judge actually starts sentencing people more harshly in real time.
Yes, the data shows it. This raises a profound question about what neutrality actually means. A judge might be formally neutral in a theoretical vacuum, but they are situated in an environment that heavily rewards severity and severely punishes leniency.
Because they want to keep their jobs.
Exactly. When tough-on-crime messaging dominates a local election cycle, the judge faces immense retention pressure. They fear the headline, the 30-second attack ad that highlights a single case where they granted bail or gave a lighter sentence to someone who later reoffended.
So the sentencing becomes defensive.
Yes. Punishment becomes campaign language. The defendant standing in front of them literally becomes political material used for re-election. The judge operates inside a structural machine that actively discourages impartiality.
That is deeply unsettling. And the inequality even trickles down to the literal paper trail of the court, right? Like the administrative clerks.
Yes, the administrative architecture itself, the paper trail itself is priced. If a defendant wants a transcript of their own hearing, to file an appeal, or to just understand what the judge actually said, it costs money. sometimes dollars per page.
Dollars per page for thousands of pages.
Exactly. There are fee schedules for filing motions, for getting certified copies of documents, for accessing electronic court records. For a wealthy person with a legal team, these fees are a minor rounding error. But for an indigent defendant, the fee schedule itself fragments their access to their own records. They are literally priced out of understanding the procedural history of their own life.
So let's recap this nightmare. If I am an indigent defendant, my lawyer is overworked and only has 4 hours for my entire case. The judge is looking over their shoulder at a campaign attack ad. The jail is breaking my spirit and costing me my job. The prosecutor is threatening me with a mandatory life sentence if I don't take a deal. And I can't even afford to buy the transcript to read what happened to me.
That's the machine.
If a person somehow survives this terrifying gauntlet and signs that plea deal just to go home, they are left with a permanent criminal record. And according to Enfield, this is where the machine does something truly insidious. It uses that record to multiply itself.
This is one of Enfield's most profound and original insights. We have to look at the doctrine of recidivism enhancements. Habitual offender laws, 3 strikes laws, prior record enhancements. Current judicial doctrine, guided by a line of Supreme Court cases like Almendarez-Torres, Apprendi, Ewing, and Erlinger, generally allows the state to use a person's prior criminal record to drastically increase the statutory penalty of a new crime.
Meaning, if a person commits a specific crime, the sentence is normally, let's say, X. But if they have committed crimes before, the sentence for that exact same action is suddenly X plus 10 years, or X plus 20 years.
Correct. Enfield argues that this creates what he calls the record multiplier. Think about everything we just discussed: the weak, overloaded counsel, the crushing jail pressure, the wealth-based detention, the trial penalty. That unequal, coercive machine produced the original prior record.
Right. They took the plea just to get out of the cage.
Exactly. The defendant likely took a plea just to survive the pretrial pressure cooker. Now, years later, the state brings a new charge against that same person and uses that old record, the product of an unequal system, to enhance the penalty for the new charge.
Oh, I see.
It is compounding the original unequal protection. The machine multiplies its own prior outcomes and calls that multiplication justice.
Wait, hold on. I can hear people listening to this and objecting right now. If someone commits 5 robberies, it's just common sense to punish them harder the 6th time to protect the public, right? Are we supposed to pretend history doesn't exist? The state is definitely going to argue that repeat offenders are fundamentally different from first-time offenders.
And that's a very fair point. But Enfield's nuance here is incredibly important, and he addresses that exact objection. He's not saying that prior history is constitutionally invisible or that judges must suffer from amnesia.
Okay, so history still matters.
Yes, the state can consider a person's history for individualized sentencing within a normal, established statutory range. So if the penalty for a robbery is 2 to 10 years, a judge can absolutely look at a person's record and say, you have a history of this behavior, so I'm sentencing you to the maximum of 10 years instead of the minimum of 2.
A parole board can look at history, too.
Exactly. A parole board can look at it when considering release. A probation officer can look at it.
So where does it cross the line into an unconstitutional multiplier, then?
The constitutional violation occurs when the state uses the prior record to change the statutory structure itself. It's one thing to sentence within a range. It is another to say, because you have a prior record, the maximum penalty for this crime is no longer 10 years. It is now a mandatory life sentence.
I see the difference.
You must prosecute the act, not enhance the person's status into a lower legal caste.
Let's make this concrete. Can you walk me through the Ewing v. California case? Because I feel like this perfectly illustrates the difference between prosecuting the act and prosecuting the status.
Ewing v. California is a stark, devastating example. Gary Ewing was a man with a severe history of drug addiction and several prior felony convictions, primarily for burglaries and thefts.
Okay.
In 2000, he walked into an incredibly wealthy pro shop at a golf course in El Segundo, California. He slipped 3 golf clubs down his pants leg and tried to walk out.
Just 3 golf clubs?
3 golf clubs. They were priced at $399 each. He was caught immediately.
Okay, so he stole about $1,200 worth of golf clubs. Normally, what is the penalty for that?
Normally, stealing those golf clubs would be a relatively minor felony, perhaps grand theft, or even a misdemeanor, depending on how the prosecutor charged it. It might carry a few months in county jail, or maybe a year or 2 in state prison.
Okay.
But Ewing was in California, and California had recently passed a sweeping 3 strikes law. Because Ewing had prior qualifying felony convictions, The theft of the golf clubs triggered a massive statutory enhancement. The judge sentenced Gary Ewing to 25 years to life in prison.
25 years to life for shoplifting 3 golf clubs.
Yes. The case went all the way to the Supreme Court, and the court upheld the sentence in a 5-4 decision. The majority doctrine treats those prior convictions as completely neutral, fixed, mathematical data points that justify radically altering the statutory penalty of the new crime. The court deferred to the state legislature's judgment that repeat offenders must be incapacitated.
But Enfield is saying those prior convictions aren't neutral data points at all.
Exactly. Enfield argues that we should view those prior convictions as the radioactive residue of an unexamined process. We know how those prior records are generated through the pressure of cash bail, overworked public defenders, and the trial penalty.
The machine produced them.
Yes. The state first processes a person unequally, forces a plea, and then points to that unequal result to justify processing them even more harshly the next time. It creates a permanent legal underclass. In Ewing's case, the law was no longer asking what is the appropriate punishment for stealing 3 golf clubs. It was asking who has the state already labeled Gary Ewing to be.
That distinction is huge. Prosecuting the act versus prosecuting the person's status. To fix this, Enfield proposes a constitutional concept he calls the first offense equality rule. What does that mean?
It is a radical constitutional proposal. Enfield argues that every new charge must be structurally treated like a first offense.
Structurally? Like how?
The core charge structure, the sentencing range, the bond posture, the plea leverage, it must all begin on equal footing for the present act, regardless of the past. The state cannot use the radioactive residue of the broken assembly line to permanently alter the boundaries of a person's liberty.
Wow. Okay, so if that is what happens in the courtroom, if the assembly line is that broken, we have to ask a much bigger question. Who holds the keys to the factory?
Right. Who built the machine?
Exactly. Lawmakers write the criminal codes, they decide the mandatory minimums, they write the 3 strikes laws, they control the budgets that systematically underfund the public defenders, and they confirm the judges who hand down the sentences. To find the root of the inequality, Enfield argues we have to look completely upstream at the lawmakers themselves.
This is where Enfield connects the gritty reality of the criminal courtroom to the broader constitutional architecture of the United States. The unequal machinery doesn't magically appear out of thin air in the courthouse. It is engineered in the legislature. If the lawmaking structure itself is distorted or captured by wealth, then the laws it produces are fundamentally unequal before they ever reach a defendant.
And this leads into his historical analysis of the United States Senate. He specifically looks at the original Article 1 of the Constitution versus the 17th Amendment. How did the Senate originally work?
Originally, under Article 1, Section 3 of the Constitution, U.S. senators were not elected by a popular vote of the general public. They were chosen by the state legislatures.
So the people in your state house picked them?
Yes. The founders designed it this way intentionally. The House of Representatives was meant to represent the passions of the people, directly elected by the public. But the Senate was designed to represent the institutional sovereignty of the states themselves. The state legislature was the constitutional hand that placed the senator into federal office.
But in 1913, the 17th Amendment was ratified, which changed all of that to direct popular election by the people of the state. So we all vote for senators now.
Yes. And Enfield's argument hinges on a very specific, deeply entrenched part of the Constitution. Article 5.
What does Article 5 say?
Article 5 outlines the process for how we amend the Constitution, but it contains an unamendable provision. It explicitly states that no state, without its consent, shall be deprived of its equal suffrage in the Senate.
Equal suffrage, meaning every state gets an equal vote, regardless of population. Rhode Island gets 2, California gets 2.
Right. And the standard accepted legal doctrine says the 17th Amendment is perfectly valid because every state still gets 2 seats and 1 vote per senator. The arithmetic didn't change.
Makes sense.
But Enfield argues this ignores the structural architecture of the institution. He says equal suffrage wasn't just about the number of chairs in the room, it was about the state legislature's direct institutional role in selecting who sits in those chairs. By removing the state legislature's hand, the 17th Amendment preserved the arithmetic shell, but completely obliterated the architecture of the office.
I hear the historical distinction, but what does this actually mean for the criminal defendant downstream? Like, why does it matter to a person sitting in a jail cell how their senator got to Washington?
It matters profoundly because of how the 17th Amendment transformed the accountability and the capture of the senator. By making the Senate a popular statewide election, entry into federal legislative power became entirely monetized.
Monetize how?
Well, a state legislature is a defined small institutional body. A state electorate is a mass political field of millions of people. To win a statewide election, you need mass persuasion. Mass persuasion requires massive amounts of money, media saturation, polling operations, party machines, and donor networks.
TV ads, digital buys, all of it.
Exactly. The 17th Amendment moved the gate to the Senate out of the State House and directly into the campaign marketplace.
Which ties right back into how campaign finance works in this country. And we have to impartially mention cases like Buckley v. Vallejo and Citizens United here, because Enfield's structural analysis heavily relies on them.
Right, and to be clear, we are neutrally exploring Enfield's thesis on these rulings, not taking a side on the politics of campaign finance.
Of course.
So, direct vote buying, handing a voter a $20 bill to vote for you, is highly illegal. It is a federal crime. But the Supreme Court, in cases like Buckley v. Vallejo and Citizens United, created a doctrinal world where spending unlimited amounts of money to shape the environment in which the voter thinks is constitutionally protected as free speech.
Money became speech.
Yes. You cannot buy the hand that casts the ballot, but you are constitutionally protected to buy the atmosphere around the voter's mind. You can fund the fear narratives, the saturation of tough-on-crime messaging, the branding of the candidate.
But hold on, let me push back for a second here. History tells us the 17th Amendment was passed for a very good reason. State legislatures in the late 1800s and early 1900s were paralyzed by corruption.
That's very true.
They were deadlocked for months, unable to choose senators, leaving seats empty. And they were taking literal bribes from corporate tycoons. The William Lorimer scandal in Illinois is a famous example. The blonde boss literally had his seat bought with cash distributed on the state house floor. Wasn't putting the vote to the people a necessary democratic reform to stop that corruption.
Enfield acknowledges that history completely.
Yeah.
He doesn't pretend that Gilded Age state legislatures were morally pure or immune to bribery.
So what's his counter?
His counter-argument is deeply cynical but fascinating. He argues that we didn't actually eliminate corruption, we just swapped its form to make it legal.
Wow.
We traded crude, localized, illegal corruption, handing a state representative an envelope of cash in a back room for sophisticated, systemic, legally protected capture. We swapped buying a few state legislators for buying the entire statewide media atmosphere.
That's a huge shift.
And in doing so, the senator transformed from a United States senator chosen for a state into a state-inhabited, donor-branded product.
So the senator owes their existence not to the institutional state, but to the massive campaign machinery that funded their multi-million-dollar statewide run. And that campaign machinery often runs on fear, division, and punitive, tough-on-crime politics, because that is what animates voters.
And this closes the loop right back to our criminal defendant.
Yeah.
If the lawmakers are captured upstream by this money-driven campaign marketplace, then the laws they write are fundamentally shaped by unequal influence.
The mandatory minimums.
The three strikes laws.
The funding cuts for public defenders.
The harsh recidivism enhancements.
Yeah.
These are the legislative products of a captured system. The law itself is no longer equally protected from manipulation. And if the law itself is bent upstream by wealth and power, the people who are prosecuted under that law downstream cannot possibly receive equal protection.
It is a closed, self-reinforcing loop. The massive wealth upstream builds the machine. The machine underfunds the defense and empowers the prosecutor. The prosecutor leverages the jail. The jail produces the plea. The plea produces the prior record. And the prior record is used to lock the person away permanently the next time they encounter the machine. It builds itself to process people rather than protect them.
That is the ultimate tragedy of the system Enfield describes.
Yeah.
It is a perfectly functioning assembly line that is operating exactly as it was funded and designed to operate.
This has been a massive, incredibly dense journey today. We started in the courtroom looking at how a docket is just a procedural skeleton, a clipboard that hides the crushing reality of the system.
We saw how the pretrial environment, specifically the trauma of cash bail and jail conditions, creates a pressure cooker that forces 95% of people to plead guilty just to survive and get back to their lives.
We examine the trial penalty, where asserting your constitutional right to make the state prove its case can result in a sentence 3 to 7 times longer, as we saw with Paul Hayes receiving a life sentence for an $88 check in Bordenkercher.
We looked at the myth of neutrality, comparing the titanium phalanx of private defense to the paper plate of a public defender who is mathematically constrained to spend only 4 hours on a felony case.
We discussed how judges are pressured by the fear of campaign attack ads, how the literal records of the court are priced out of reach of the indigent, and how the machine multiplies its own inequality through recidivism enhancements, punishing a person's status rather than their present act, like Gary Ewing getting 25 years for golf clubs.
And finally, we followed the stream all the way up to the lawmakers, seeing how the structure of the Senate and campaign finance laws allow massive wealth to buy the atmosphere that produces our laws in the first place.
The overarching theme of Enfield's work is just undeniable. A lawyer's name on a piece of paper is not equal protection. Equal protection requires the whole machine to be equal.
If the funding, the judge, the jail, the bail, the plea leverage, and the laws themselves are structurally biased by wealth and power, then the system is not dispensing justice. It is dispensing inequality, wearing the language and the robes of justice.
Before we sign off, I want to leave you, the listener, with a final provocative thought to mull over. Enfield's analysis of the justice system is devastating, but it provides an incredibly powerful lens. He suggests that a completed docket or a prior criminal record shouldn't be the end of the conversation. It should be the beginning of a question.
Right, how was it produced?
Exactly. What were the structural pressures, the invisible forces that created that piece of paper? I want you to think about applying this exact same lens to other massive systems in your life. Think about the healthcare system. Think about the education system. Are we doing the exact same thing there?
It's a great question.
Are we just looking at processed metrics like high school graduation rates or hospital discharge papers and confusing that paperwork with actual learning or actual care? If a student graduates from a chronically underfunded school reading at a 5th grade level, but they are handed a diploma, the system checks the box and says they were educated. If a patient is discharged from a hospital still sick because their insurance ran out, the system generates the chart and says they were treated. When the massive systems in our society process you, are they actually protecting you, or are they just generating the paperwork to prove they did their job?
Something to really think about.
It brings us right back to where we started, that statue of Lady Justice. Maybe she isn't blindfolded so she can be impartial. Maybe the system tied that blindfold around her eyes so she wouldn't have to look at the machinery operating right in front of her. Thank you for joining us on this complex, rewarding deep dive into the source material.